Hi everybody. Week 8 and search and seizure. I'm a lawyer and I'm going to love this section. So you're going to see a lot of it on the next exam. So make sure that you take time reading the chapter, looking at the slide deck, listening to this, and hopefully I think it's 9 key topics that are there will be helpful for you. This chapter, I think, is really important because, one, it'll prep you for CRJU 350, search and seizure, or Fourth, Fifth, and Sixth Amendment. What I would suggest you do with this is you make some notes from this, especially the way that I lay out the rules, so that you can have an outline and you can use the slide deck to help you. There's a little bit of not conflicting information, but information in the book that makes it apparent that it was not really prepared by a lawyer or somebody who was highly schooled in criminal legal affairs, and criminal procedure is the is the area of the law. So let's start out basic. First, you're used to working in the area of concepts within criminal justice and the social sciences, and you get tested on concepts. Whenever you get a criminal law, criminal procedure question, remember it's about rules. And that's a whole different type of study than it is for concepts. For rules, you need to make either flashcards or an outline or some method to sit down and memorize rules. The good part about this section is if you go into law enforcement, when you go into the academy, you're going to have a learning domain in the academy that'll be search and seizure. And if you have this outline available, you'll rock it. You just have to add the cases in there and understand what the cases meant. If you're going to go to law school, this will help you in criminal procedure. And it won't be so much hide the ball, because you'll have an idea of the rules. Hopefully some quick study will refresh them, and then you'll be able to make whatever changes come up in the rules before you get to school, or before you take exams in law school. And then the third thing is for people that are going to graduate school or are going to continue on in some other fashion, some other part of the industry. This will really help your critical thinking. So, concepts versus rules. Understand we're talking about rules. First key point, standards of proof. And there's 6 that we'll talk about. First is a hunch. And that is no suspicion. And it doesn't get the officer any place. I had a hunch this person was involved in criminal conduct, and I stopped them. Well, no, that's not correct. You have to have specific facts that lead you to reasonable suspicion. You'll study that in Terry versus Ohio. And understand, from Terry, you're going to pull out particular rules. The rules are outlined in the slide deck. The next area, our standard of proof, is preponderance of evidence. Preponderance of evidence means that more likely than not, the fact being argued is true. For many of you, the first thing you think of when you hear preponderance of evidence is the standard for liability in civil cases. Well, it also has a criminal law application. And I test on this in written assignments in this course, and people always get this wrong because they don't look any deeper. Okay, it's on the civil one. Well, no, it's also the standard of proof needed for the police to prove that a person gave up a constitutional right, meaning they agreed to a search. They agreed to speak to the police without an attorney present. That's what that standard is used for. The next is probable cause. It's for an arrest. Probable cause is for an arrest warrant, also a search warrant. The next standard of proof is clear and convincing evidence. And that's what's needed to be proven by the prosecution, by the defense, back and forth, by the defense when trying to prove insanity. and non-culpability for a crime. The last one is proof beyond a reasonable doubt to obtain a conviction. Standards of proof. Next key point. Only 3 times the police can conduct a search. Warrant, consent, exigency, meaning an emergency. A warrant is pretty obvious. Arrest warrant to take somebody into custody. Search warrant to actually search a place. And then consent, and it has to be free and voluntary. That's the standard for that. Consent is free and voluntary. Exigency is, the best way to think of it is a life-threatening emergency or serious felony for certain things, and we'll talk about those more directly. 3 times the cops can search. Oh wait, I think I mentioned to you that I'm a lawyer. So then there's 3 times the police can search, and then there's a whole bunch of exceptions. So let's talk about the exceptions. The first, when you look at seizures of persons, the police interrupting a person's life, they happen a couple different ways. First, consent, a consensual encounter. Hi, can I talk to you? That's a consensual encounter. When the police say, hey, come here for a minute, that is a detention based on Terry versus Ohio. The next is an arrest, when a person is in custody and is not free to leave. Now understand, under a detention, a person isn't free to leave either. And if they decide they're going to leave, it's a 100-year-old clock. I gotta have it. If the person decides they're going to leave, then they're probably going to get arrested, and that's going to be a bad outcome for somebody. From there, searches of persons, warrant, consent, exigency are the 3 times you can search a person, but also under Terry, you can do a pat-down search for weapons only, outer clothing. Can't go into pockets unless, of course, you feel what you think might be a weapon, a knife, a gun, but razor blade, something of that nature. Perhaps a syringe. Seeing with methamphetamine, see a ton of syringes, where in the past, generally, years ago, you would see that for heroin, and even meth would be snorted. And not injected, but now it's injection is really popular, so cops got to be super aware of getting stuck. Then we have the search incident to a lawful arrest. And what that means is that a person is lawfully arrested and that there is some nexus to what's being searched for or a danger to officers. Person's going to be put unattended in the back of a police car. Well, then you can search pockets. Then you can search waistband, shake pants to get whatever's in the underwear to fall out. I know you probably didn't need to hear that. Sorry about ruining your week. But at that point, you can do those things. Instant to a lawful arrest. The last one, the 6th way to search a person, is a booking search. Let's move on to buildings. Buildings are pretty easy. Warrant, consent, exigency. Only 3 ways you can search a building. You might carve out a little niche of, say, incident to a lawful arrest, but when you think about that, if you go in and arrest somebody, you could only be the area that it's immediately around them, and for weapons or evidence of the crime that you're investigating. If you find something else, that comes up under another doctrine called plain view. And we'll talk about that in a sec. Searches of vehicles, warrant, consent, exigency, and then there's 4 more. Kind of cool. Like Terry, you have the pat-down of a vehicle. The next area is instant to a lawful arrest. But Gant pops up again. Gant versus Arizona. Kind of a case that you need to know, especially if you're going into law enforcement. I think it leads to some really bad habits in officers, but it's what the court has decided the standard should be. Probable cause. Now, you'll say, well, police have probable cause to conduct a search of a person, probable cause to conduct a search of a building. They had really good information that they were going to find meth sales. Well, if they have probable cause and they want to search a building, they need a warrant. Cops can go in and make sure everything's stopped so that none of the stuff can be destroyed or thrown or destroyed or leave the building, a house, for example, but can't search until they have that warrant. And extremely important issue when it comes to that. Probable cause in a vehicle, though, however, vehicle's mobile. It can be driven. It can go away. So if the police in a stop have probable cause that there's contraband in a vehicle, let's say the cops walk up and used to be really easy with burning marijuana, and now, of course, marijuana is legal. Let's say what could we see? Oh, police see bullets in a holster lying on the floorboard of a car. Pretty reasonable that you're going to find a gun. I think you're going to be okay with a probable cause search based on that. Finally, for vehicles is inventory. Inventory is when the cops are going to tow a car. The police department has a procedure which requires that all vehicles being towed are searched. The public policy for that is to avoid stuff getting stolen from cars and the operators and the police going, we never saw that. And also to protect the police and operators from false complaints of theft. So, the last area of searches are special searches. Probation and parole. Persons on parole, they will have signed a document saying that they've given up their Fourth Amendment rights. And once they do that, they can be searched at any time without reason, without cause. California versus Davenport, I want to say, is a case where the Ninth Circuit tried to impose a reasonable suspicion standard on parole searches, and it was struck down by the High Court fairly quickly, actually. And then you have probation searches, and they have their own special rules as to when they can be, when the person can be searched based on probation violations, or if they're on probation, arrived on vacation, left on probation. So the last area of searches, highly regulated businesses, and this is places like bars, mechanics, places that sell explosives or deal in hazardous materials. The police can do searches, limited searches, without a warrant in those locations. Warrants, as I mentioned before, you've got the arrest warrant, arrest misdemeanor, arrest felony, both have different rules. You have the search warrant, and the search warrant has rules as to when you can perform a search, and the idea of knock and notice, letting the person inside or people inside know that the cops are out front and they're coming in. The concept there, the public policy, is to avoid bad things happening in the house. Meaning, person's door blows up and guys come in and they're armed. Person may arm themselves, and then you've got a deadly confrontation. So those are warrants. Identifications, that's the next area. And you're going to see, because you'll do some stuff in classes about mis-IDs and bad identifications. You know, there's three types of identifications. Let's take the one that's used the least first, and that's a lineup, to where you bring multiple people in and you do a live lineup in front of the victim or witness, and then they select. It's the classic TV thing, you know, with the thick glass and then lights and then the height chart and all of that. Classic stuff. Kind of cool for TV, not necessarily accurate as to how it goes, because it's not really used that much, because you've got to have a jail to get people to you know, fill the lineup, or you go around and you put five guys in police uniforms and one guy in a jail, you know, custody uniform. Okay, which one is the person that assaulted you? You know, that's going to be unduly suggestive, and that's what the police are trying to avoid. The next one is the infield lineup. Infield lineup is, and the cops, crime happens, the cops stop somebody that matches the description or some other, you know, way. He's driving a car that's described, and then they will take a person, the witness, you know, or victim, to the person that's detained, and then they will have them look at them and determine whether or not they were involved in the crime. Now, it would seem like it'd be pretty easy if, you know, if it happened, if it's contemporaneous with the crime, but it's interesting that there are quite a few misidentifications from infield lineups. If you're going into law enforcement, cops, be really, really aware of the of this issue, and if you don't like it, then do some more investigation before you act on it and arrest somebody. First off, it will save you a ton of paperwork, and then second off, it may save the city and you a lawsuit. The last one, which is the one which is used frequently, is the photo array. And that's where the cops get the bad guy's picture, usually from DMV now, and then 5 similar, but not exactly similar photographs. A couple different ways to do it. We used to put it in a file folder with 6 holes cut in it, and it was called a 6-pack. And the person would look at them all, look at the people, and then go through and say, okay, then it's number 4. I've got an example of that in the slide deck. However, there's quite a bit of discussion about the proper way to do a photo array and the least suggestive. First off is double blind, meaning that you have a person who has no idea what the case is. They just know that their fellow detectives are working a case. And then the person doesn't know who the bad guy is. And that person will go in with 6 pictures, put them down in front of the victim or witness, and tell them to go through them one at a time and look for the person that that was involved in the crime. And this, of course, is accompanied by an admonishment. And the admonishment's pretty easy. It says that you're going to be shown so many pictures, or you're going to be shown a person who is detained. They may or may not be handcuffed, and the person that is involved in the incident may or may not be involved, may not be in the photographs. And it's just as important to free the innocent from suspicion as it is to identify the guilty. I mean, a really important thing to say, this admonishment. Better if it's written down. Most agencies have a document that people will sign before they see it, and then they can write a narrative as to what they're thinking when they see the pictures. So it's really quick what the IDs are about. The next area is admissions confessions, a vibrant area of the law, all kinds of information there. So I'm just going to talk about the Miranda rule here, and that's twofold: custodial interrogation. When you watch TV and you see somebody get arrested, in a movie or a television show, and the first thing they do is, after they put the handcuffs on, you hear the last click of the handcuffs, they immediately read Miranda rights. Fiction. The only time the police need to read Miranda rights is if they're going to do a custodial interrogation. Person's arrested, handcuffs, we're getting there. And they're going to ask them pointed, embarrassing questions about the incident that's involved. If they don't do Miranda, then the argument now becomes, was this custody or not custody? And, you know, you see more and more where the courts have allowed the police to handcuff people and then go through this. But I think the cops are really pushing their luck when they, you know, rely on that. The Sixth Amendment, when does the Sixth Amendment apply? There's a whole bunch of rights. Right to counsel, right to a trial, right to a jury, right to this, right to a whole bunch of stuff in there. That's under the Messiah doctrine. Again, a whole bunch of other rules. Just understand for the feds, a critical incident is when, or critical point in proceedings is what the rule is, which generally for the federal government, federal cases, is going to be an arraignment. When a person's arraigned, they then have the right to counsel. They have a right to counsel before the arraignment if they're going to be asked custodial questions. So understand those are two different issues. California, the last thing today, California rule is when the police seek charges, a person has a right to counsel. So, as an example, the police develop a case on somebody and they get an arrest warrant. They go out to the person's house to serve the arrest warrant. So they've already gone to the court, they've already sought charges, they have a warrant in hand, they're going to go arrest the person. They knock on the door, a person answers, it's amicable at this point. He invites the officers in, the officers sit down. He's not handcuffed, he's not in custody, and they start to ask questions about the incident that they're investigating. Well, in California, he has a right to counsel as soon as they look for charges, and they will, and if they ask questions, they're not admissible. Okay, that is 4th, 5th, and 6th Amendment in hopefully not too long. It really important part. It leaves the cops into all kinds of difficulties. It's fraught with danger for the police to make mistakes and have issues. So with all of that, I think you're in decent shape. Remember, it's rules, not concepts. With that in mind, see you on class.